BPD conducts unconstitutional strip searches. In addition to impermissible Terry frisks, our investigation found many instances in which BPD officers strip search individuals without justification, often in public areas, subjecting them to humiliation and violating the Constitution. Strip searches are fairly understood as degrading and under the Fourth Amendment are reasonable only in narrow circumstances. Strip searches are never permissible as part of a pre-arrest weapons frisk. Following an lawful arrest, the reasonableness of a strip search turns on the scope of the particular intrusion, the manner in which it is conducted, the justification for initiating it, and the place in which it is conducted. Absent specific facts indicating that an arrestee is concealing a weapon or contraband, officers may not strip search a person incident to arrest for an offense that is not commonly associated by its nature with the possession of weapons or contraband. Moreover, courts have repeatedly emphasized the necessity of conducting a strip search in private, Amici versus West. BPD policy likewise recognizes that strip searches should be conducted only under very limited and controlled circumstances, and that strip searching suspects in public view or on a public thoroughfare is forbidden. But it wasn't forbidden when this lady cop, whose sexuality might be considered abnormal, I say might, strip searched these two women on a California highway in full view of the oncoming traffic, and the officer shoved her gloved, I take that back, her hand wasn't gloved, she shoved her hand up both ladies' vaginas and anuses on a public highway. You can find that one. Nevertheless, our investigation found that BPD officers frequently ignore these requirements and strip search individuals prior to arrest in public view or both. I forgot to mention, this is on page 33. Numerous Baltimore residents interviewed by the Justice Department recounted stories of BPD officers jumping out of police vehicles and strip searching individuals on public streets. BPD has long been on notice of such allegations. In the last 5 years, BPD has faced multiple lawsuits and more than 60 complaints alleging unlawful strip searches. In one of these incidents, memorialized in a complaint that the department sustained, officers in BPD's Eastern District publicly strip searched a woman following a routine traffic stop for a missing headlight. Officers ordered the woman to exit her vehicle, remove her clothing, and stand on the sidewalk to be searched. The woman asked the male officer in charge, "Do I really gotta take all my clothes off?" The male officer replied, "Yeah," and ordered a female officer to strip search the woman. The female officer then put on purple latex gloves, pulled up the woman's skirt, and searched around her bra. Finding no weapons or contraband around the woman's chest, the officer then pulled down the woman's underwear and searched her anal cavity. This first search found no evidence of wrongdoing, and the officers released the woman without charges. Indeed, the woman received only a repair order for her headlight. The search occurred in full view of the street, although the supervising male officer claimed he turned away and did not watch the woman disrobe. After the woman filed a complaint, BPD investigators corroborated the woman's story with testimony from several witnesses and by recovering the female woman's latex glove from the search location. Officers conducted this highly evasive search despite lacking any indication that the woman had committed a criminal offense or possessed concealed contraband. The male officer who ordered the search received only a simple reprimand and instruction that he could not serve as an officer in charge until he was properly trained. An African-American teenager recounted a similar story to Justice Department investigators that involved two public strip searches in the winter of 2016 by the same officer. According to the teenager, he was stopped in January 2016 while walking on street near his home by two officers who were looking for the teenager's older brother, whom the officers suspected of dealing narcotics. One of the officers pushed the teenager up against a wall and frisked him. This search did not yield any contraband. The officer then stripped off the teenager's jacket and sweatshirt and frisked him again in front of his teenage girlfriend. When this search likewise found no contraband, the officer ordered the teenager to give your girl your phone. I'm checking you right now. The officer then pulled down the teenager's pants and boxer shorts and strip searched him in full view of the street and his girlfriend. The officer report of the incident disputes this account, claiming that they did not conduct a strip search and instead recovered narcotics from the teenager during a consensual pat-down. No narcotics were ever produced to the teenager's public defender, however, and the state's attorney's office dismissed the drug charge for lack of evidence. The teenager filed a lengthy complaint with BPD describing the incident and identifying multiple witnesses. The teenager recounted to us that shortly after filing the complaint, the same officer approached him near a McDonald's restaurant in his neighborhood, pushed the teenager against the wall, pulled down his pants, and grabbed his genitals. The officer filed no charges against the teenager in the second incident, which the teenager believed was done in retaliation for filing a complaint about the first strip search. Other complaints describe similar incidents in which BPD officers conduct public strip searches of individuals who have not been arrested. For example, on September 2014, a man filed a complaint stating that an officer of the Central District searched him several days in a row, including undoing his pants and searching his hindquarters on a public street. When the strip search did not find any contraband, the officer told the man to leave the area and warned that the officer would search him again every time he returned. The man then filed a complaint with Internal Affairs and identified the officer who conducted the strip search by name. When Internal Affairs investigators pressed the man to provide a detailed description of the officer, the man recalled that the officer had red patches with sergeant stripes on his uniform. The investigator recognized this description as patches worn by the officer in charge of a shift and confirmed that the officer named by the man was working as an officer in charge in the Central District on the dates the man alleged he was strip searched. Internal Affairs nonetheless deemed the complaint non-sustained without further explanation. That guy needed somebody to have taken a video of that incident. Deficient oversight and accountability has helped perpetuate BPD's use of unlawful strip searches, period. Although the department's policy limits strip searches to specific narrow circumstances following an arrest, BPD supervisors have failed to ensure that officers comply with this policy, and internal affairs officials have not adequately investigated frequent complaints that officers violated. BPD does not separately categorize or track complaints alleging unlawful strip searches, but our manual review of BPD's internal affairs database revealed more than 60 such complaints in the last 6 years, only one of which was sustained. In response to dozens of other strip search complaints, Internal Affairs has deemed them administratively closed, classified them solely for administrative tracking, or found them not sustained after minimal, if any, investigation. For example, in 2015, an African-American male filed a complaint stating that he was strip searched by an officer whom BPD eventually fired in 2016 after numerous allegations of misconduct. The man stated that the officer ordered him out of his vehicle during a traffic stop and searched the vehicle without the man's consent. Then when the stop of the vehicle did not uncover contraband, the officer pulled down the man's pants and underwear, exposed his genitals on the side of a public street, and then strip searched him. The officer seized marijuana and cash during the strip search and allegedly told the man that the officer would return his money and drugs if the man provided information about more serious crimes. The complaint stated that when the man did not provide this information, the officer arrested him and turned over only part of the confiscated money, keeping more than $500. Despite the serious charges in this complaint and the officer's lengthy record of alleged misconduct, Internal Affairs deemed it administratively closed without interviewing the complainant. This type of inadequate oversight has allowed BPD's unlawful strip search practice to continue. I'm not understanding this because either those officers got their jollies from sticking their fingers or hands up people's butts or fondling their genitals, or something else was going on with this. And as soon as that went down, especially the cavity invasions, the guys that investigated this, those guys have no morals. Our investigation likewise found reasonable cause to believe that BPD's approach to street-level crime suppression has contributed to officers making thousands of unlawful arrests over the past 5 years. This pattern has three main components: warrantless arrests made without probable cause in violation of the Fourth Amendment, arrests for minor offenses such as failure to obey and trespassing in circumstances that violate the Due Process Clause's requirement to provide fair notice of prohibited conduct, and investigative detentions that exceed the limits of Terry and constitute arrest. BPD arrests individuals without probable cause. The Fourth Amendment requires that stops be supported by probable cause. Probable cause requires a probability or substantial chance of criminal activity and is evaluated by examining the totality of circumstances. It requires the kind of fair probability on which reasonable and prudent people, not legal technicians, act. Police may satisfy the probable cause requirement by obtaining a warrant prior to arrest or determining that probable cause exists in the field. Our investigation determined that when BPD officers make arrests in the field without a warrant, they often do so without probable cause. Data maintained by the state of Maryland shows that from November 2010 to July 2015, BPD made thousands of arrests that reviewing officers declined to charge. The state's data records information about each person arrested. The state's data records information about each person arrested and arresting agencies, all charges levied, and whether reviewing officials found that the charges were adequately supported. This data captures several stages of review of officers' justification for each arrest. When a BPD officer makes a warrantless arrest and brings the arrestee to central booking, a supervisor at booking determines whether to commit the arrestee into jail, release the arrestee on bond or on their own recognizance or with a citation, or to nullify the arrest and release the detainee without charge. For all cases except where an arrestee is released without charge, a representative from the state's attorney's office then conducts an initial review of the charging documents to ensure that they recite probable cause. This review usually occurs the same day as the arrest and looks only at the officer's stated justification for the arrest, not evidence from any other source. In some cases, the state's attorney's review finds that an arrest lacked probable cause or otherwise should not result in filed charges. Analysis of this data reveals that from November 2010 to July 2015, supervisors at central booking released 6,736 arrestees without charge. Prosecutors from the state's attorney's office declined to charge an additional 3,427 cases, explicitly finding that 1,983 of the underlying arrests lacked probable cause. In summary, BPD officers made 10,163 arrests that authorities immediately determined did not merit prosecution, an average of 200 arrests per month. BPD's pattern of making arrests without probable cause is more pronounced with non-felony offenses that stem from street encounters between officers and residents. For example, during the last 5 years, prosecutors and booking supervisors rejected 1,350 disorderly conduct charges, 20% of the total. Arrests for other highly discretionary nonviolent offenses were nullified at even higher rates. Officials rejected 24% of disturbing the peace charges, 23% of failure to obey charges, and 24% of hindering charges. Officials likewise rejected 156 trespassing charges, comprising roughly 5% of the total, and these numbers almost certainly understate the extent of BPD's problematic arrests, as they reflect only cases dismissed during preliminary review based on facial deficiencies in officers' reports, not arrests later shown to be invalid during pre-trial hearings or at trial. Indeed, our review of a random sample of 150 incident reports describing the probable cause for these discretionary arrests found that officers frequently recite facially inadequate justifications. In particular, these reports reveal that officers often arrest individuals for trespassing where the person arrested was standing on a public street that bordered property owned by the city or a private party. Such conduct is not criminal. Individuals in this country have sufficient liberty interest in standing on sidewalks or in public places. City of Chicago v. Morales. Several examples highlight this pattern. On June 11th, an officer dispatched in response to suspected drug sales observed an African-American male fitting the description of one of the suspects. The officer wrote in his report that the suspect was standing on a public street in front of property owned by the mayor and city council of Baltimore City. You gotta be shitting me. When the officer approached, the man became nervous and could not provide a valid explanation for being at that location. Lacking any further evidence suggesting that the man was involved in narcotic sales or other criminal activity, the officer nonetheless transported the man to Western District Headquarters for debriefing and then to Central Booking, where the man was charged with trespassing. The man was not charged with any other offense, and the officer's account of the encounter furnishes no basis for the trespassing arrest. Rather, it shows that the man was merely standing lawfully on a public street. In January 2010, officers similarly approached a man who was standing in front of 1524 Mount Moore Court looking around, and who walked away when he saw officers. Officers stopped the man and arrested him when he could not provide a valid explanation for being in front of the address, excuse me, which is part of the Gilmore Homes public housing complex. In another case, an officer arrested an African-American man observed standing in front of 578 Orchard Street. The officer's report explained that when he approached, the man began to walk eastbound on Orchard Street, attempting to elude the officer. The officer stopped the man and asked him why he was standing in front of 578 Orchard Street and if he knew the resident who resided there. When the man replied that he did not know the resident, the officer arrested him for trespassing. The officer's account of these and many similar incidents describe facially unlawful arrest for conduct that is not criminal. BPD arrests people lawfully present on Baltimore streets in violation of due process. Baltimore's application of city ordinances banning loitering, trespassing, and failing to obey an officer's order violates the Fourth Amendment. Citing these provisions, BPD frequently arrests people who are lawfully present on public sidewalks without providing the constitutionally required notice that they are engaging in prohibited conduct. These arrests are unconstitutional under the void for vagueness doctrine, where they are made in circumstances that fail to provide the kind of notice that will enable ordinary people to understand what conduct it prohibits. The actual law says to remain in one place with no apparent purpose, but it was invalidated. Where conduct like loitering is generally lawful, people may make arrests only where the arrestees violated the ordinance knowingly. Moreover, absent clear standards and an intent element, a dispersal order itself is an unjustified impairment of liberty and cannot form the basis of an arrest for failure to obey. The Williams Court reversed the defendant's narcotics conviction after finding that the defendant's underlying arrest for loitering violated due process. The court noted that although BPD officers claimed the man was part of a group that was impeding pedestrian traffic on a sidewalk, there was no evidence even remotely supporting an inference of scienter or that the defendant had noticed that such conduct was illegal. Moreover, the court held that such notice must include a specific description of the prohibited conduct. Officers could not provide sufficient notice by telling someone merely that he is loitering and that if he does not move on, he will be arrested. The same vagueness problem exists in BPD's enforcement of trespassing statutes against individuals who are standing on sidewalks adjacent to public housing or private establishment. Indeed, a federal district court in Maryland has expressed concern about the type of highly discretionary trespassing arrest that BPD utilizes. In the Diggs versus Housing Authority, 1999, the court enjoined enforcement of the City of Frederick's trespassing ordinance and noted that a policy of issuing citations to persons with no apparent legitimate reason for being on housing authority property may raise serious due process concerns in light of the Supreme Court's recent decision in Chicago v. Morales. Okay, I'm going to stop it right here and pick it up after page 37.